Good afternoon, everybody. Welcome to today's webinar. We're just waiting for everybody to be admitted into the session and then we'll make a start. So just bear with us for a moment. Okay, I think that is everybody admitted into the session, which is great. So we will make a start. So I'd like to welcome you all here today to our CBAM policy update webinar. This is the fifth webinar that we've done this week for International Trade Week. Really excited to be here today to chair this session along with my colleagues to explain CBAM policy and what UK exporters need to know. Really excited to be chairing this Chamber Customs webinar in partnership with the British Chambers of Commerce and also the Department of Business and Trade. So I'm just going to go through for the first moment or two our introductions, a little bit about what we do, who we are, and then I'll hand over to my colleagues to start the session. Okay, so who we are. So Chamber Customs, for those of you that have attended one of our webinars already, you will know who we are. For those in the room that haven't, I'd just like to explain briefly who we are. So we are Chamber Customs. We are fully owned by the British Chambers of Commerce, and we deliver training, consultancy and declarations through the local chambers of commerce and in collaboration with the local chambers. So really excited to also be here with William from the BCC, Emmanuel from Chamber Customs and Valeria from the Department of Business and Trade. So we'll just go around the room and do some introductions. So my name's Mitch. I'm the Deputy Director of Trade Services at the British Chambers of Commerce and Chamber Customs. Really excited to be chairing this webinar. It's kind of CBAM is the forefront of the mind at the moment, and it's something that I've been hearing a lot as I've been traveling around the UK and on the road, speaking to traders and businesses in the supply chain. So really excited to be chairing this and taking you through this session over the next hour. So I'd like to hand over for an introduction over to Valeria from the Department of Business and Trade.
Thanks, Mitch, and good afternoon, everyone. I'm Valeria Vigilante. I'm the Europe, East Asia and Digital Trade Lead in the FTA utilization team, and as part of my role, I basically lead on supporting businesses in getting to grasp with specific EU regulations such as EU CBAM, and that's why I'm going to be covering here today. I will hand to William.
Hello, thanks very much indeed for joining everyone. William Bain, Head of Trade Policy at the BCC, covering everything from Windsor Framework to FTAs and CBAM, very much in the centre of what we do. Emmanuel.
Hello, good afternoon everybody. My name is Emmanuel Gianquito. I head consultancy and training for Chamber Customs. So I'll be bringing you some of the examples and complaints and experiences that our traders are facing when dealing with CBAM.
That's great. Thank you very much. So we're going to talk you through the agenda and set the scene for the session. Before we do that, just a reminder, if anybody has any questions for our panelists during today's session, please use the Q&A function and not the chat. So the chat will not be monitored, but the Q&A panel will be. So please feel free to raise a question. If we have the opportunity during the session and at the end to answer that, then we'll try our very best to do that throughout the next hour. So the agenda today is going to be giving a CBAM overview. Valeria will talk more about the DBT support. We'll hand over to Emmanuel for some practical examples, and then over to William for policy insight, and then a bit about how we can help you as a trader and a business and a supply chain, followed by, if we have the time at the end, to do a bit of an open question and answer session. So don't want to take much more time up. That's kind of my role done for the moment. So I'm going to hand over to the experts who will be taking the floor for the next kind of 45 minutes. So I'm going to hand over to Valeria. Thank you.
Thank you, Mitch. and yes, good afternoon again. So let's start with some of the basics. So what CBAM actually stands for the Carbon Border Adjustment Mechanism. Now I said it the name in full once, and you will excuse me. I'm gonna use the acronym for the rest of this webinar as it's slightly less complicated and less burdensome. But CBAM is part of the EU Green Deal policy and is designed to complement the EU emission trading schemes and applies only to specific products, those products that are more like carbon intensive goods, and applies to goods that are imported into the EU and is designed to mirror basically the cost, the carbon emission cost that EU producers will face when producing those products in the EU versus the goods that are imported into the EU. As I mentioned, only certain goods are in scope. So we got iron. No, Emmanuel, you can go to the next slide. Thank you. Yeah, we got iron and steel. We got aluminium, fertilizer, hydrogen, and cement. So the EU, in terms of like deciding which products are in scope, has kind of like determined these 6 sectors, but has also listed specifically the products that will follow in scope or not within those 6 sectors. So if you're in doubt, I will encourage you to actually consult the EU CBAM regulations, because those are listed, and they're listed using the CN nomenclature. So those of you who are already familiar with exporting will already use that nomenclature already, and that's the best way of actually checking if your products is in scope or not of CBAM. Can we go to the next slide, please? Right. So as I mentioned, EU CBAM applies to imported goods into the EU, and as such applies basically to all parties involved in the supply chains and the import of these products in the EU, such as the manufacturers of the actual goods that are covered under the measure, exporters to the EU, EU importers. Those are also usually referred as declarants under the CBAM regime, but also custom brokers and authorized representatives that might handle the procedures for either the importers, the exporter, or the manufacturer more generally. Can we go to the next slide, please? And just to be crystal clear on who actually should be complying with EU CBAM, the regulation requires EU importers of the goods covered in the regulations to collect, verify, and report greenhouse gas emissions data for the products, and to buy what we call, the regulations actually calls CBAM certificate for the embedded emissions in their products. So the burden of compliance relies on the EU importers, but what does it mean for you as a UK business exporting to the EU? If your goods are in scope of CBAM, your EU customers will be responsible for compliance, but they will likely ask you for information and for data in order to help them complying with the regulation. Can we go to the next slide, please? Right, so kind of like these are kind of like a very quick whistle-stop tour on the kind of like what EU CBAM is, and I know that others alongside me we're going to go into the far more details of the practicalities and the nuances of EU CBAM. So I just wanted to use a few minutes here to showcase the support that DBT offers for UK businesses that are exporting to the EU and more generally exporting, but also they will need to comply with EU CBAM. So as some of you might already know and use, DBT is unifying all its support for businesses in what we call the business growth service, and that's bringing together the business support to scale up and grow domestically with the export support that is already existing to help businesses in exporting. And this is all present in one platform, business.gov.uk, which I hope some of you are also, actually most of you already use and familiar with. Next slide. And here in this case, I just wanted to kind of like spotlight specific support that exists there for you as a business if you're navigating EU CBAM and you're trying to understand what's required from you by your clients. So first of all, we have the Export Academy, which is completely free and offers a very wide range of online trainings from foundation courses to masterclass, but also sector and market events. But as part of that, there is what we called a series called Unlock Europe, which provides a wide range of webinars, but in particular offers webinars on EU CBAM compliance. There already been a few in the past, and there are others in the pipeline, including the one in a month time, actually, on the 5th of December, which is about getting ready for EU CBAM, but has a slightly different focus than the usual webinars that the Academy offers. This one is going to be far more practical because we're going to have a panel of businesses and other experts talking about the experience of complying and getting ready for EU CBAM. So you can hear directly from the expert, also from other businesses that have been through the process or going through the process. Alongside that, we have the Export Support Service, which is your first point of contact. So if you have any queries around EU CBAM, you can submit your inquiry through the business.gov.uk form, and I'm assuming the slides will be shared, but like you can click, there is the embedded link there, so you can click and it will take you directly to the form, and you can submit your request, and you will receive specific guidance in answer to your question. And related to that, we have in-market support, so colleagues working in Europe that can provide you more specific support and answer more specific queries. We're currently covering 29 markets across Europe, and we can also provide one-to-one advice. And again, you can access that through the Expert Support Service. And then the last but not least, we're putting together some EU regulations explainers, including one on EU CBAM. These explainers will be available on business.gov.uk in early December, and they will provide you with kind of like the key information on CBAM and what you need to do in order to be compliant with and to support your EU customers in complying with, and also signposting to the relevant EU resources. And this is actually the last point I wanted to mention today. As the policies is developing, and they're all the EU Commission's produces new information, I will always say that the best point of kind of like source and information is the EU Commission website if you want to know the latest that's happened and what the latest the EU Commission has decided and has kind of like implemented in relation to EU CBAM, and you can easily find it by googling EU CBAM. Is one of, I think it's the first one, if not it's one of the first link that will come up, and is a quite extensive pool of resources. So that's all from me. And I'm going to hand over to Emmanuel, who's going to talk more about the practicality of EU CBAM.
Thank you, Valeria. A great whistle stop tour, and definitely there's lots of support that is available for free to UK businesses, and I think that's fantastic to see, and it's really, really good. Now, I want to pick up on a couple of things that you said and highlight them, because it's what we're seeing in practice, and I think it's important to stress. So what we see as Chamber Customs, we help businesses, UK businesses, who come to us and they actually are a bit lost in this regulation. I'm sure this is not news to you. So we have different types of businesses who come to us. We have businesses who do very little to products in the UK. They're what we define as merchants. They are businesses who buy products from different places around the world, and then they just sell them again. You know, they stock the product here and they sell them to clients, including clients in Europe. And then we have customers here who actually do a lot. So they might buy some raw materials, some steel bars, and then they cut them and they do wonderful things, and they transform raw materials into widgets and things that they sell. Now the end product gets sold to the EU, and when that end product falls within the CBAM scope, as you said, they get worried because suddenly they fall within the scope of CBAM regulation. A few things to mention. you very rightly you highlighted those beautiful categories, and then you said the important thing is the HS code. Now I'd like to take a moment and really highlight that, because we have done some very quick consultancy exercises where the first question was, what products do you export? And as soon as the commodity code became clear, we could confirm whether the products were or were not in scope. And people get quite confused. So I'd like to make that really clear and say it doesn't matter what products go into your final product. It doesn't matter if you include steel in your product. What matters, what defines if you are within the CBAM scope or not, is the resulting commodity code. So if you're using steel, and I'll give you a practical example, we have a client who creates something that is called an RF filter. Is a metal box with some electronics inside. The biggest part is the metal box outside. They import metal box, and if they sold empty metal boxes, those products would fall within the CBAM category because the HS code is a metal box. But once they create an RF filter, the code moves into something with an 84 category, and 84 does not fall within the CBAM category. Even if they have steel products inside their product, the resulting commodity code does not fall within it, so they don't have to do CBAM. So that's an important one that I wanted to highlight. So commodity code and classification, I think in one of the webinars that we did yesterday with a Canadian colleague who spoke to us about US tariffs, he said that the classification is the mother and father of your compliance. If you don't know what your HS code is, or if you're not sure, double check. We've had clients who have undertaken a HS review, and as a result, they've realized that they don't have to do CBAM. That's not the solution, but it's definitely possible and it's worth checking. The other thing that you said, Valerie, which I thought was really interesting, is that, and clearly this is bread and butter for you, so you know it very well, and it's clear to you, the responsibility for CBAM, the burden of proof lies with the EU importer. Now, I apologize for stressing this, but this is so important. An EU regulation, please correct me if I'm wrong, cannot be enforced on a UK company. So the way I normally present this is that there is a difference between a legal responsibility and a commercial responsibility. So as UK businesses, we don't have a legal responsibility to Europe, but we have perhaps a commercial responsibility to our customers in Europe who are purchasing our products. And if we don't provide that information, we become less interesting suppliers. So it is important that we are able to provide that information, as you put it quite rightly, to allow the EU importer to comply with that regulation. That's the important bit. Disclaimer, this is different if, as a UK business, you decide to sell to your customers in Europe under DDP Incoterms, delivered duty paid, because that means that as a UK company, you have taken contractually the responsibility of configuring yourself as the importer of record, therefore falling into the CBAM regulations. That's a complex scenario, which, you know, if you're doing DDP, you should know what I'm talking about. If you don't know your Incoterms, plenty of support around that. So so that's the other thing with the commercial responsibility. For me, that's absolutely key. Now, we are seeing a lot of information coming out, and I will ask William to walk us through all the changes that have come in, because what we've noticed is, what we've seen is that businesses have, let's say complained, or they've opposed resistance to this EU regulation because they've indicated that it's been perceived as additional red tape and is slowing things down and is creating problems. And from the ground, we've been helping a lot of businesses who have been threatened by their clients in Europe, you know, that either you provide this information or you're out, you're no longer in our supply chain, which is damaging. Now, we have helped a lot of businesses comply. We have helped a lot of businesses learn how to calculate emissions and how to report emissions. The CBAM calculations are different from other things we've done before. They're not the same as EPD. They're not the same as other carbon footprint calculation that have been done before. And it's important to understand that difference. What the EU has done, they have listened to comments and complaints, and they have addressed all of them in a mega review that they call the omnibus review, which makes me smile, and I'm sure that William will talk us through, because it's been ratified by European Parliament recently, a bit later than we would have expected, but it's now European law. Unfortunately, and if William, you have more information on that, I would love to hear that, we haven't seen the implementation notes, those notes which will transform legislation into practical guidance for businesses. And the things that specifically I'm waiting to see is clarity on how a UK business has to validate their calculation. We know from the legislation that you have to validate your calculations. You can't just say, well, you won't be able to just say, my emissions are 2, 3, 4, whatever the number might be, but you have to get somebody external to review that your calculations have been done properly. We know that that is needed, but we still don't know how that should happen. The other thing that I have a complaint on behalf of all the customers that I've worked with is, again, that burden of proof that Valeria, you indicated. What happens is your European importer has to report figures. And so they turn to the last party who sold to them, for example, the UK business, and say, you must provide that information to me. And so I deal with UK businesses who come to me and say, I have to provide this information to my European customer, but I'm not manufacturing the screws, or I'm not manufacturing the metal boxes, I'm buying them. And I'm not getting that information. So how do I do it? And there are mechanisms, because you can report what we call default values, and they will be more allowed in future. And William, hopefully you'll tell us more about that. But they do have a higher cost. What I have a complaint about is the fact that if you include default values, it doesn't look good for you as a UK business, because it looks that your calculations are based on estimate, when it's not your fault, when you are relying on upstream information. That's a bit of a problem that has not been addressed yet. And finally, the whole confusion that came in with the de minimis exclusions. So as you probably, William, you will cover that the EU allows European importers, what we call European small importers, European importers who import less than 50 tons a year across all of the CBAM products, not to report. Basically, CBAM does not apply to small stuff, it applies to big stuff. Apologies, this is my layman term interpretation of the regulation. But that poses a problem, because I could be, as a British business, a small producer, yet I might be supplying to a big buyer. And so even if I am a small producer as a third country installation, I might still have to do my calculation. So I'm not sure how this easement for the EU business is helping the rest of the upstream supply chain. Now, I appreciate we don't make EU policy, but I know that you're very close to the lawmakers, and you make our view known from the UK businesses. So I just wanted to raise these points, and I'm very interested in what you've been hearing and what you think might be coming on this front. Yeah, so if I can come over to you, be very interested in some of the answers to these comments and observations from what we are seeing from the clients who come to us for advice. So, William, I think if I can come to you, that would be great.
Great. Okay. Thank you very much indeed, Emmanuel. And if I can start off by going through the details of the omnibus regulation that was passed and is now entered into force from the 20th of October this year. And it's important to think about the process that has been happening, which is that, as Emmanuel said, all EU companies who were importers of record were, facing quite a substantial degree of compliance work, gaining information from suppliers, some of them outside the EU, like UK companies, issuing the quarterly reports to their competent authority in their own individual member state. And there was, through some of the business organizations and trade associations who liaise with the European Commission in Brussels, quite a sense that this autumn, with the focus being on growth in the EU as much as it is here in the UK, that relaxing these burdens would, in that sense, equip companies to better go for growth and spend more of their resources growing their business. And that argument began to attract a degree of sympathy in the European Commission. And alongside that, of course, we have the definitive phase implementation of the EU CBAM due from the 1st of January next year. We're in the transitional phase still at this point. So the Commission had to wrestle with how to respond to this request for, in a sense, less red tape on importers of record, looking at the details about the goods with embedded emissions in the sectors and scope that had been made over around 18 months, and then working out that the vast majority of the embedded emissions were actually coming from a smaller subset of companies, primarily larger companies. And so the policy response that was made in terms of when the omnibus regulation was drawn up was to effectively exempt about 90% of SMEs, EU importers, from the red tape of the compliance steps under EU CBAM. Now, the omnibus simplifications have reaffirmed that 1st of January 2026 is the date in which the definitive phase implementation goes ahead. There were some business voices within the EU saying that that date should be deferred. Other countries, particularly some in Africa and in Asia, saying that they felt that these CBAM rules were constituted a trade barrier, and indeed the EU should be rethinking and delaying the definitive phase implementation. But in the end, the Commission agreed and got the permission of the Member States and the Parliament to adopt a modification to deal with the red tape burden, but to go ahead with the full tenets of the CBAM policy. And the important thing to remember about what changes from the 1st of January is that the obligation to purchase and surrender EU CBAM certificates, and that really is a function of the difference in the carbon price between the origin market of the goods and the EU, covering those embedded emissions in the 6 good sectors which are in scope. That obligation begins, the liability starts from the 1st of January. Now, the actual purchase and surrender of CBAM certificates is deferred in practice until February 2027, but the liability begins from the 1st of January. And if we look at the position in the UK, I mean, earlier this year, there was around a 30% differential in the carbon price. So the EU carbon price was 30% more than the UK. In terms of some policy developments that we'll talk about in a few minutes, that gap has been closed almost entirely. I mean, as we speak on the 5th of November, actually the UK spot carbon price is a little higher than that of the EU. So market forces have resulted in that differential being eliminated. And that is down to the fact that we now strongly expect that both sides, the UK and the EU, will negotiate a deal to link the emissions trading schemes of both territories, and that will, through market forces, mean the carbon price effectively will become the same. But for other third countries where ETS linkage is not being considered at all. And if goods are coming from another third country into the EU, then absolutely where that difference in carbon price is reflected, then EU CBAM certificates will require to be purchased and surrendered to make good that difference in the carbon price. Because how the EU treats that is that, in a sense, it's about leveling up the playing field. And if you have imported goods from territories where the carbon price is lower, that is seen to be a form of unfair competition that has to be accounted for through the purchase and surrender of CBAM certificates. That's the carbon leakage phenomenon of making goods in areas of the world where the carbon price is less and then importing them into territories like the EU where the carbon price may be similar. And the whole aim of this policy is to deal with that phenomenon of carbon leakage. Now, these simplifications, as we say, took effect a couple of weeks ago through Regulation EU 2025/2083, and this reduced the administrative burdens on EU importers of record. And a corollary of that is also what the third country producers need to do as well, supplying those importers of records in the EU from CBAM compliance measures. And accompanying the simplifications were the creation of a de minimis exemption. And so this means that goods amounting to annual imports of 50 tons or less of CBAM goods with embedded emissions, these are exempt. So if you're importing in the EU less than that quantity of goods, then you're exempt from the requirements of the rules. Now, from the de minimis exemption, hydrogen and electricity were excluded. So they do not count towards the de minimis, and of course those are treated in a different way. But the overall effect of the regulation and the simplifications and exemption is that 90% of EU importers were exempted from mid-October from the requirements around CBAM. Now, to make good the system for the introduction of the definitive phase of CBAM from next January, some changes were also made in that regulation to CBAM declaration times. So the deadline for EU importers to submit their annual CBAM declaration, that was extended from the 31st of May in the following calendar year to the 30th of September in the following calendar year. And that is to allow both the importer of record, but also the third country supplier with more time to prepare and finalize the data. And that means that when it comes time to purchase and surrender certificates, it's being done on the basis of fully accurate and authenticated data. Because that is much better when you start introducing this fiscal element and payments of money in terms of definitive phase. And on the next slide, some of the other facets of the omnibus regulation. So as Emmanuel said, standard annual average carbon prices or default carbon prices can be used in respective countries where carbon pricing mechanisms are in place, but the actual carbon price paid cannot be established. And this is an important point because what the omnibus regulation does is say, and this was quite a controversial change that was introduced, what it says is, where you have made a good and it is comprised of components or inputs that have come from a previous third country, so you're part of a supply chain and you've imported products, which have come from another third country, then you can, where you can quantify what the value of the embedded emissions in those goods or precursors is, reduce that from the payment overall, which is due in terms of the definitive phase of CBAM. So you can deduct accredited costs made in other countries before the goods have arrived in EU for final manufacture. And to do that, you've got to have full data, obviously, in terms of what the embedded emissions were. You've got to have data and keep that data for 4 years. So that is quite interesting. That does diminish the potential liability that companies will face in terms of dealing with definitive phase. But of course, if you don't have, in terms of these extended supply chains, the details about what the embedded emissions were and quantities and reports, the issue of default values can then be used. This is around countries where there are default carbon prices in place. So that issue of the third country deduction can still be very significant, even where you find it very hard to get the evidence from the supplier in your extended supply chain about what the value and level of the embedded emissions were in the precursor product that you've made into a new or a finished product. So that's an important change in terms of the omnibus regulation, and one that bears scrutiny and getting expert advice on. Another thing which the regulation does is permit authorised CBAM declarants, and that's normally the importer of record, or as Emmanuel said, in certain circumstances where you're engaged in DDP, you may have assumed that responsibility yourself as the supplier in the UK. So authorised CBAM declarants can delegate submission of their CBAM declarations to a third party. Doesn't affect their responsibility, but they can delegate that to another party. They must be established in an EU member state, however, and hold an EORI number in order to perform those duties. So that again was a significant change made in mid-October. And this will not be the end of where policy within the EU on CBAM develops, because there is a broader review of this legislation which is due. There are considerations being given to whether the range of sectors should be expanded. I mean, this is in line with some of the changes that the EU is considering to in expanding its emissions trading scheme into another phase. And also, that review of CBAM legislation could cover downstream goods, which are covered by the CBAM itself. So it is an evolving picture, and over the next couple of years, there's likely to be additional changes to how the system works. But it's very clear that the EU has settled upon the 1st of January being the key date for the definitive phase implementation. And it does not appear at this point that there are changes likely to that. The next slide, please. Now, how does all of this affect us in the UK? Many of you will have heard about the EU-UK Reset Summit and negotiations. Earlier this year, may have heard about the phrase common understandings, and how that impacts goods trade and energy and electricity. Well, in Chapter 4 of the Common Understandings memorandum issued in May, it was agreed by both the UK government and the European Commission and European Council that negotiations would take place on the linkage of the UK and EU emissions trading schemes. So let's be clear what that is. Not making a single emissions trading scheme, but linkage. And that is something that the EU has done already with Switzerland, for example. And that meant, in terms of that agreement, that Switzerland is exempt from the EU CBAM. Switzerland itself does not have a CBAM of its own, but it has fiscal measures which the Commission is happy deal with issues of carbon leakage going into the Swiss market. Now, the implications of this commitment in the Common Understandings document are very clear. So both sides now propose to negotiate a conjoined market for carbon allowances and a common carbon price through the operation of market forces. And we saw that divergence of around 30% by earlier this year really being eliminated by market forces. And when the linkage agreement enters into operation, you will see the carbon price, really permanently become the same across the conjoined market. Now, this phenomenon requires a number of things. So what's known as dynamic alignment. So the UK keeping in lockstep with EU rules about certain energy policies and emissions trading scheme policies and potentially the scope of emissions trading schemes, all of that being required in order to provide an exemption from the EU CBAM when this deal is negotiated and when it's implemented and comes into effect. So this requires really the UK and the EU to retain an aligned net zero target achievable by 2050. So again, that's become something that's quite a live political issue, something we're hearing a lot about, but that is going to be one of the requirements in order to have ETS linkage, is to have that degree of regulatory alignment, and that's a very significant policy development. Linked ETSs would include emissions from electricity and industrial heat generation, emissions from industry, domestic and international maritime transport, and domestic and international aviation as well. So those are the essential things that would have to be common between both ETS schemes. And the benefits of ETS linkage, which the BCC supports, and many British companies, not just in the energy sector, but in sectors like aviation and maritime, have been supporting, is you have reduced carbon leakage risk in the conjoined market. The purpose of CBAM is to prevent or diminish carbon leakage. So moving to linkage means you have a sort of common zone where there's equivalent protections against carbon leakage, dumping of goods into a market where production has occurred in territories where insufficient account is taken of carbon leakage risks. Also, ETS linkage provides a legal framework to maximize investment in clean energy. People will know what the rules are going to be in terms of energy movements between the UK and the EU. And also we should bear in mind that ETS linkage will also have implications for Norway and the EEA EFTA3 countries. So very likely there will be replication of these arrangements with the EEA EFTA3. And of course, Norway, a major player in provision of energy for the UK and a partner in the development of the North Sea. Now, ETS linkage would exempt UK companies from EU CBAM. So it would be very similar to the approach which Swiss companies have in terms of the linkage agreement on ETS between the EU and Switzerland. So this would be a major change. But this does not happen unless or until an agreement is made, until it's legally brought into force, implemented, and until that point, both sides, particularly UK companies exporting into the EU of CBAM goods, must comply with the rules as they are. Now, the BCC has called for a linking mechanism whilst negotiations take place. We may get an update later this month about the official starting date of formal negotiations around this. But for the moment, at least, there is not any immediate prospect of such a bridging mechanism being granted by the European Commission. So again, it just emphasizes the importance of complying with the existing rules, getting the best advice you can in order to continue with the obligations as they are, whilst this process goes on. and whilst we find out what the final agreement is and when the implementation date of any such agreement would be. And it's also important to recognise this would be quite a profound change in our regulatory relationship with the European Union. So it would require, for example, very strong form of alignment, an international agreement, bringing in common governance. The European Court of Justice would have to have the final say on legal questions that would arise from the linkage agreement. So very significant negotiations. The BCC is strongly involved in this process and being briefed now on a weekly basis by government in terms of developments around this, and we expect to hear more later this month from ministers and senior officials about the starting point and progress of negotiations on ETS linkage. And that takes us on to my last slide, which is about what is happening here in the UK. And yes, the UK will have a CBAM. And legislation is due. It may be potentially contained in the finance bill this year after the budget. The BCC has made comments and representations to government, to Treasury particularly, about the draft provisions on the UK CBAM, which were published. We called, for example, for more clarity in some of the clauses around Northern Ireland and Northern Ireland status, which ETS linkage will help resolve, and that's been a big issue for companies in Northern Ireland. So we made comments on the technical basis of the legislation, which Treasury published in draft, but that will need to go through Parliament. Also, there are some issues in terms of the design of the UK's CBAM scheme, which need to be resolved, particularly if a successful linkage deal with the EU on emissions trading schemes is reached. Bear in mind, there's a different way that the EU and UK CBAM are trying to enforce things. So the EU CBAM is about the phenomenon in terms of definitive phase, particularly about purchasing certificates, surrendering certificates in order to make good any differential in the carbon price. In terms of the UK CBAM, it will be more of a traditional fiscal measure. So there will be a quarterly CBAM charge set by the Treasury every 3 months based on market assessment and market forces. And it will be a charge, a tax, effectively paid directly to the Treasury. So it will operate in a slightly different way to the EU system. But again, what we've seen with Switzerland and the EU is there are different ways to secure proper action against carbon leakage. Switzerland doesn't have a CBAM at all, and yet there are no CBAM obligations between both sides. So these issues can be resolved very well within the scope of a linkage agreement. So let's look at some of the things that the UK CBAM legislation will really have to resolve and have settled by the time we get to implementation here in January 2027. So, as we said, it will adopt a quarterly CBAM levy based on the UK emissions trading scheme price, carbon price. So that will be reviewed quarterly, but will also factor in the carbon price support rate in the calculation made by Treasury. So there will be fluctuation in the charge from quarter to quarter potentially. There are some differences in goods in scope of the UK proposed CBAM. So, for example, electricity is not covered, and that's different from the EU CBAM. But glass and ceramics are within scope of the UK scheme. So we shall see whether those issues survive the ETS negotiations or whether there will have to be much fuller alignment between the goods and scope in both CBAMs. Negotiations will determine that. The initial accounting period, given the start date of January 2027 for UK CBAM, will cover really the whole of the 2027 year. So importers will have until the 31st of May 2027 to make initial first declarations and initial payments due under the levy, but the initial accounting period will be for the whole of that calendar year. From 2028, there will be some changes. So reporting will be done on a quarterly basis, and this will cover scope 1 and 2 emissions in products, plus selected precursor emissions from iron and steel, fertilizers, aluminium, and hydrogen. Glass and ceramics will be added to this later. So still quite a bit of detail on what precursor emissions in terms of iron and steel will be precisely in scope. Treasury will need to engage with business around the specific details on that. And remember, of course, in the UK, it's going to be the importer of record here, which has the main responsibility for accounting and paying for any taxes due. Of course, drawing on the information obtained from third country suppliers and customers overseas. And finally, consignments of less than £50,000 in value over a rolling 12-month period will be exempt from the UK CBAM. So again, they've gone for a financial valuation rather than a tonnage valuation, which the EU have shifted to from last month. But that de minimis threshold seemed to be important to exempt a lot of small importers who are not responsible for importing goods with a great deal of the emissions. Rather like the EU market, in terms of UK importers, it's a smaller cohort of larger importers who are doing most of the importing of goods that might be susceptible to carbon leakage. So there we are. That's an overview of a lot of activity in terms of policy and legislation happening in Brussels, happening also in the UK. Our negotiations, which we hope will be officially underway very soon between the UK and EU over ETS. So a lot happening, a lot that Chamber Customs and BCC will be able to update you on and take you through every step of the way as this process goes through. And the best advice is to get the advice of sound and solid professionals who know what they're doing around CBAM. And over to you, Emmanuel, someone who every day encapsulates that.
Thank you, William. As always, lots of interesting information. So I have a comment I wanted to make, and it's something that you said before. I've had a lot of clients basically saying, "Oh, but a deal has been announced between the UK and the EU on CBAM. We don't need to worry about CBAM because, basically we don't have to do it anymore." And I don't know how heavily I can stress that this could take years in coming to fruition. I mean, if I look at how long it took Switzerland to get into an agreement with the EU to be exempt, it took 8 years, something like that. So, I mean, I really want to stress what you said. At the moment, things are in place and companies have to follow the current rules. It might be that we get to the alignment. We hope so. We hope that our government stick to the net zero plan that has been established and et cetera, but for now, we have to comply with the current regulation. Is that right?
Absolutely.
Great.
In a nutshell, spot on.
Great. And that's for me really, really important. I then wanted to take us to some question, Mitch, because I can see that there are some questions that are quite specific to what William was discussing. I've answered some of them in the chat, and Valeria's answered some, but in the interest of time, we only have 5 minutes, so I think there were some specifically for William.
That's great, and yeah, appreciate that. Thanks for both of you for answering the questions to keep on top of the Q&A, which has been great. But you are right, there is a couple in there that we can hopefully answer in the next 5 minutes. So one question that was put in there was from Gemma, and that's relating to the £50,000 valuation that's on the current slide. And Gemma asked, is the £50,000 valuation for all of the goods in the consignment, or just the ones that are covered by CBAM under them commodity codes? So, William, if you want to expand a little bit more on that.
Yeah, just the CBAM goods. So it's £50,000 in imports of CBAM goods only, that comes within that de minimis threshold. Yeah.
Great, thank you very much. And then one from Sol here, who says that he doesn't think that glass and ceramics were still included in the UK CBAM after the latest consultations. So, is there an update on glass and ceramics in terms of product?
Well, I think the sense is that we may get, I mean, the government might bring forward a kind of freestanding bill, which legislates for CBAM, or it may include clauses in the finance bill. And of course, that would go through much quicker, wouldn't have to go through the House of Lords in the same way. So we are expecting to see the final scope of the primary legislation in the next few weeks. The budget's on the 26th of November, and the finance bill would typically be a couple of weeks after that. So we will see for certain at the end of November what the government has done in terms of the final shape of this consultation. But what we've said is that on these latter elements of design work around UK CBAM, they should be speaking strongly with business.
That's great, thank you. And there's one that's just come in here, and I think this is one for you, Emmanuel, from John, who says, if we have CBAM goods, where will the certificates come from? So I think maybe we could just explain more about the reporting side rather than any kind of certification.
I think John might be meaning like the certificates that have to be surrendered. So, John, I'm going to try and frame the question before I answer. So, as a UK, if you're a UK third country installation, you do not have to do anything for the EU CBAM scheme. It's not up to you to worry about the certificates. You have to provide information to your EU client, and you have to explain what emissions you have added to your precursors, as we were saying before. Based on that, your EU client, when they import, they will do reporting, and then they will sort out the financials through the surrendering of certificates that they might have to buy. In the UK scheme, as William was explaining, that's something that will have to be defined a bit more clearly in terms of what fiscal measures and how that will work exactly. I hope I've answered your question. I may not have got the angle correct, but please let us know if that's the case.
That's great. Thank you very much. Well, we're coming to the end of our time together. So just if we can move over to the next slide, and we'll just do a summary here. So firstly, I want to say a huge thank you to Emmanuel, William and Valeria for guiding you through not only the practicality, but also the policy and the understanding of what CBAM is. So thank you for getting all of that information in 1 hour. There is a lot to take in there, but we've managed to stick within the time. So that's great. On the screen now, there's a QR code, and this will take you through to our Chamber Customs CBAM health check. This basically allows you to get some further guidance on basically whether your goods are in scope or whether they're not in scope. So please take the free health check. Please scan the QR code, have a go, because I think it's really important to really understand if your goods are in scope or not. And actually, what we've learned through the last six or 7 months of speaking to traders around the UK is actually there is a lot of misunderstanding in relation to, are the goods in scope or are they not? And some companies that thought that their goods were not in scope actually, from taking the health check, realised that actually the goods do fall under the scope. So it's worth taking the check and having a look there. And as William said, the Chamber Customs team are here to help, as are the British Chambers of Commerce through a CBAM policy perspective, and also Valeria and her team at the Department of Business and Trade. If we could move forward to the next slide. We've done that already, so maybe to the next slide.
I'm pressing.
And then the next slide. There we go. So on the screen there's an email address and contact number for our team at Chamber Customs. And as I said at the start, we're here to provide consultancy training and declaration support for UK traders. So if anybody needs our support, then please feel free to reach out and get in contact with us. I'm not sure if there's a final slide on DITC, but if not, I can always just mention that.
Just mention it. Sorry, the slide is missing.
No problem. We are running our Driving International Trade Conference in central London at the QE2 Centre in March next year, and would love for you to join us. So please go onto the British Chambers of Commerce website, have a look at that event and all the information on what is included in that event and how to register will be on the website for you all. So please take a look at that as well. Other than that, we are now at 3 o'clock. A final thank you to all of our panelists and experts in the room today. Thank you for joining, and we will see you soon. Thank you.
Thank you very much.